So welcome everybody to today's webinar on the EDI implications of the Employment Rights Bill. I'm going to welcome Paul Ball in a minute to talk to us. He's from the senior partner at Gateley Legal. Just to remind everybody, please switch your microphones off if they're not already off. If you'd like to ask a question or share a thought, we'll come back to those questions and thoughts after Paul's done his presentation. So use the chat box to do that. And you'll find the chat box at the bottom right-hand corner of your screen. So hopefully you can find that. And the session will be recorded so we can share it with everybody afterwards. So I'm just going to stop sharing these slides and I'm going to pull up Paul's slides now. So just give me a second. Right, Paul, can you see your slides?
I can. Lovely. Thank you,
Great.
Anthea.
Okay.
Do you want to flick it on to the next one, please?
Yes, I will. There we go.
Okay, that's me. I'm a partner in the Leeds office and the employment team of Gateley Legal. We're a national law firm, professional-led law services group. So we have a lot of complementary businesses relating to the construction and house building sector in particular, but also other consultancies that deal with things like workplace culture, occupational psychological assessments, etc. Big national law firm. Moving on swiftly from my intro, please, Anthea. So what am I going to cover today? So the agenda really is a recap about the current legal framework in relation to harassment especially. And the reason for that is that I want to also briefly mention the statutory duty to prevent sexual harassment that came into force last October, because in particular, there are going to be some changes that the Employment Rights Bill, currently in its latter stages of the parliamentary process, are likely to bring to that. So I want to sort of do a little bit of scene setting first of all, and then a discussion on raising some awareness of some of the key changes that the Employment Rights Bill is likely to mean for all employers, all businesses in relation to sexual harassment and harassment in general. And then a brief mention of some of the other EDI implications of the bill as and when it becomes law and when they may well come into force. But as I say, the main focus today is going to be on conduct at work towards employees, in particular relating to harassment. Just so you know, at the end of these slides, I have got a QR code. So if people want to scan that QR code, you can click to get a fuller set of these slides. These are some summary ones. So you can click to get a fuller set of these slides. And Anthea, I will circulate a link for the fuller set that you can circulate to people afterwards, along with a brief evaluation form. So if at the time when we're doing the questions at the end, people don't have enough time to click onto the QR code and download a copy of the slides, on the brief evaluation form, if people could want a copy of the slides, they can just simply say somewhere on that form, please send me a copy of the slides, and we can get them to you that way. Okay, so what is the concern for organisations with regard to harassment in particular? Give you a bit of context for the legal position. Well, this slide and the next slide are just a couple of snapshot of the kind of headlines that we will all have seen over the last few years relating to inappropriate behaviour in the workplace, the implications of that on employees, and the implications of that often several years later on businesses. Think about McDonald's, think about Harrods earlier this year. BBC has had issues with this as well. Many organisations have faced a great deal of scrutiny about how they do, and more importantly, or more often, how they don't take steps to ensure that the workplace culture lives up to the values that they profess in public, and they don't necessarily prevent people from behaving in a manner towards other people which is acceptable or not. And all of these things come summarise into a number of areas of concern for businesses. So if you move the slide on, please, Anthea, in terms of the areas of impact and concern, obviously it can impact on reputation and brand, increasing grievances, employment tribunal claims, financial impact of claims, potential fines, lost business, recruitment costs, and so on. Stifles innovation. It can mean that you're not necessarily an attractive business and not able to retain people. Those of you, if anybody on attending today who on a specific HR role, raise your hands if you think you'd have liked to have been in HR in Harrods at any point earlier this year. I suspect there'll be nobody putting their hand up at that particular question. and it can impact on productivity and performance. But more importantly, and overarching all of that, is because workplace behavior and workplace culture, and getting that right and making sure that people are treated with dignity and respect, either when they're working for you or when they're accessing your services, it's the right thing to be doing. But you'd be surprised by how often businesses haven't necessarily got that right. So if you can move on to the next slide, Anthea, I'm just going to do a little bit of sort of scene setting with regard to why I think harassment is a subject that's really important to sort of raise awareness of, not just now, but why the landscape's going to be changing. It's become quite a political topic and a hot topic as a category of misbehaviour for nearly a decade now. In 2016-17, proposals were first mooted about strengthening the law around sexual harassment in particular in the workplace. And this followed on from several high-profile sexual harassment scandals, and it was the development and following on from the Me Too movement and Harvey Weinstein, etc. This led in 2018 to a public inquiries into the issue here in the UK, and then just before the pandemic, the Equality and Human Rights Commission published a report on the prevalence of sexual harassment in workplaces and harassment more generally, but with a particular focus on sexual harassment. And actually, this makes really sobering reading. It's still available now, and it's still relevant now, but it makes very sobering reading in terms of the statistics from broad respondents to their report. Statistics about the prevalence of sexual harassment and harassment in general in the workplace. The majority of this being male to female behaviour, not exclusively, but predominantly male to female. One of the telling things, though, was that the survey that the Equality and Human Rights Commission had conducted showed a huge discrepancy between the statistics of the percentage of women who had been subjected to sexual harassment and the percentage who had reported it to their employer. And the most common reasons given why women who'd been subjected to sexual harassment didn't raise concerns about it was, first of all, fear of repercussions, fear of not being believed, and a belief that it really wouldn't make any difference even if they did speak up. But this report also highlighted that many managers didn't even have a clue about what their obligations would be in the event that a sexual harassment report was made to them. And this report by the EHRC recommended a number of changes, and that also included proposing a mandatory duty on employers to take reasonable steps to protect workers from sexual harassment in the workplace. This finally led to the government consulting on legislation, but because of the pandemic, nothing really happened until 2023 when we got draft legislation, and that was finally passed in the tail end of 2023, and it was the Worker Protection Amendment to the Equality Act bill. I'm going to talk on that in a moment, but it came into force in October 2024 as a new duty to prevent sexual harassment. I'm going to say a little bit about that in a moment, but I think it's really important, first of all, just to give a little bit of context about the legal framework that harassment in the workplace operates in. So the legal framework is broadly the Equality Act 2010. This is what defines the protected characteristics that people are protected from discrimination about: age, disability, gender reassignment, race, sex, etc. It also outlines types of conduct that are prohibited, so direct discrimination, indirect discrimination, a failure to make adjustments for a disabled worker, also covers harassment and victimization. And the Act also sets out who is protected from that kind of behaviour: employees, workers, former employees, job applicants, work experience people, contractors, and then who can be liable: the employer for its own acts, but also vicarious liability of the employer for any acts by its employees which are carried out in the course of their employment. It also sets out that individual employees can be personally liable for their own conduct. And we do see, by the way, we do frequently see harassment cases in tribunal in which there's more than one respondent and there's an individually named respondent in those proceedings. And if that individual respondent is found to be liable, he or she can be found to, or can be required to pay money personally to the injured claimant. In the context of harassment, the Act also sets out three different types of harassment. So there's harassment related to a protected characteristic, so harassment on the grounds of or related to race or disability, for instance. There's also sexual harassment as a standalone type of harassment. And the third type is less favourable treatment of somebody because they have refused to submit to sexual harassment or harassment on the grounds of sex or gender reassignment. So what is harassment? Harassment also has a very specific definition in the Act. It's unwanted conduct either related to a protected characteristic or unwanted conduct of a sexual nature, which has the purpose or the effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Unwanted is just unwelcome or uninvited. Conduct can be anything: verbal, non-verbal, physical contact. In the context of sexual harassment, it has to be verbal, non-verbal, or physical conduct of a sexual nature for it to potentially amount to sexual harassment. But it can include conduct that isn't intended to cause the effect of causing a humiliating environment, intimidating somebody, or violating their dignity. What that means is that sexual harassment can occur in the workplace when it isn't necessarily sexually motivated, when it's not intended to cause any offence, but where the conduct is sexual in nature and where, in fact, it has caused offence, distress, upset, etc. A single act is enough to be sexual harassment. And acts that somebody might previously have, I'm going to put in air quotes, accepted or tolerated within the workplace can become acts of harassment or sexual harassment. Even if the individual hasn't necessarily expressly signaled previously that that kind of behaviour to them is distressing or upsetting or unwelcome. The second aspect of the legal framework is the Equality and Human Rights Commission. This has a number of duties, so it issues codes of practice and guidance on the employment aspects of the Equality Act, on the service provision aspects of the Equality Act, and those documents are intended to assist parties, in particular businesses, to know what their obligations are and the things that they ought to be putting in place to try to ensure that they are complying as a baseline with their obligations under the Act. The Commission can also enforce the Act by way of taking legal action in employment tribunals against employers that have failed to comply, more likely by investigating businesses, large businesses, in particular in certain market sectors where, for example, there might have been a prevalence of a particular type of behaviour or a spate of claims in a particular area. So it's quite a robust framework that we've got in place at the moment. But as to sort of how robust it has been, well, tribunals still deal with discrimination claims week in, week out, day in, day out. People still get treated in a manner that's unacceptable. The headlines that I mentioned on my earlier slides, some of those are, pretty good example of the fact that there is a legal framework, but it doesn't necessarily provide an adequate measure of protection. The Equality Act is largely enforced by individuals rather than the Equality and Human Rights Commission, and it's largely enforced by them pursuing either a county court claim if they believe there's been discrimination in the provision of goods and services. And that's not really an area I deal with too much as an employment lawyer. What I do deal with much more regularly is the second aspect, which is employees and workers pursuing individual employment tribunal claims if they believe they've been subjected to discriminatory treatment in the course of their employment. It's important to note that if the tribunal claim arises and that claim is successful, tribunals have powers to make a declaration that discrimination has occurred, recommendations about things that ought to be done by that business to try to ensure that that behaviour doesn't get repeated, and then most commonly and most importantly, awards of compensation. That can include financial losses that have flowed from the acts of discrimination. So if somebody had been subjected to a discriminatory dismissal, for example, loss of earnings that they have suffered as a result of that can be awarded. And it's important to note that there's no cap on the amount of compensation that could be awarded in a successful discrimination case. Unlike an unfair dismissal claim, where broadly speaking the cap is 12 months salary, in a discrimination case there is no cap. In addition to financial losses, tribunals will award compensation for injury to feelings based on the impact that the discriminatory treatment has had on the claimant. And this is done with reference to 3 bands, which are called the Vento bands: lower, middle, and top band. The figures for those bands change each April. Just as a rough benchmark, though, the current figures for discrimination awards, for the lower band, it's from anything from 1,200 quid to just over 12,000 quid. The middle band is just over 12,000 quid to nearly 36,500 pounds, and the upper band is just shy of 36,500 pounds up to over 60,000 pounds. And in extreme cases, higher awards than that can be made. And even a single act of discrimination could give rise to an award of 1,200 to 2,000 pounds, and the size of the award will depend on the nature of the behaviour, the people who have perpetrated it, the particular quirks or otherwise personality type of the individual, the duration, and how long the behaviour has lasted, and whether the employer has not done anything about it when it's been aware of it. And so it's not uncommon for quite substantial injury to feelings awards to be made, in addition to significant loss of earnings awards. Anthony, if we can go forward to the next slide, please. One thing it's important to mention as well, though, if a tribunal claim does arise, it's not taken as read that the individual will be successful. The employer has always had the opportunity to try to defend itself from complaints of discrimination if it can show that it satisfies this reasonable steps defence. So an employer won't be liable if it's able to show that it took all reasonable steps to prevent the employee who carried out the act of discrimination from acting in the way that they did. This usually is a two-stage approach. First of all, what steps the employer has taken to prevent that behaviour. Secondly, is there any other steps that the employer could have taken that it didn't take? Ordinarily, this is about what policies an employer has about acceptable workplace behaviour, what safeguards it has got in place to try to prevent unacceptable behaviour of a discriminatory nature, and then secondly, how effectively it has implemented those policies through training and raising awareness. I've been an employment lawyer now for more than 30 years, and I can probably count on one hand the number of cases where I felt a client of mine has got much prospect of successfully raising that defence, because the majority of businesses prior to now have often had policies in place that deal with acceptable and unacceptable behaviour. It might deal with what harassment is, and they might cover that at employee induction, but then forget about it. Training gets put in a drawer, they don't update the training and do very little else to keep this issue and the standards that are expected in the forefront of all employees' minds. Some employers actually do a lot more. And there was a recent tribunal case involving a trust in NHS trust in South Yorkshire, where they were able to show that they had complied with this, but they'd taken more steps than just simply having a policy. They were able to show and display evidence that supported that their cultural values and the consequences of not complying with those cultural values in terms of disciplinary sanctions against employees was front and center of communications on a regular basis. It was up on notice boards. It was regularly referred to in team briefs, team meetings. Training was repeated on an annual basis, and that was enough to satisfy a tribunal in a particular case. The employer in that situation had taken reasonable steps. So that's where the law was up to last October. Anthony, if you can move the slide on, please. The landscape in terms of workplace harassment with regard to sexual harassment changed substantially last October, and that was on the back of the introduction of the Worker Protection Amendment of Equality Act in 2023. This introduced, with effect from October last year, a duty on employers to take reasonable steps to prevent sexual harassment from occurring in the workplace. This is a duty that the Equality and Human Rights Commission can enforce, but the important thing is that it comes with teeth. This is in addition to the obligation on employers to take reasonable steps if it wants to maintain the defence that I mentioned on the previous slide. Claim is upheld, then the tribunal has the power to increase compensation by up to 25% if it is not satisfied the employer has taken reasonable steps to prevent that sexual harassment from occurring in the workplace. I've summarised on this one slide, this one bullet point at the end, the key aspects of this. It's about clarity in your policies, training, repeat training for employees, investigating issues when they arise and doing that thoroughly and doing it impartially, and taking prompt action against reported harassment. Now, I'll say a little bit more about that on the next slide, because this does come with real teeth. We haven't yet seen any reported cases where a tribunal has increased compensation. That's largely due to the fact that the employment tribunal system is incredibly stretched, and those of you who deal with or have to deal with any employment tribunals for your businesses will probably not be surprised when I tell you that we're seeing cases that might be issued now not going through for hearing perhaps for another 2.5 years or so. So we aren't yet seeing reported cases coming through the system, but that 25% uplift isn't just on injury to feeling compensation for the act of sexual harassment. Tribunal has the power to award an uplift of 25% on every successful Equality Act claim that there is in that claim. Even if only one of those complaints is a sexual harassment one, and there's a load of other complaints, the failure to comply with this duty could lead to the tribunal uplifting compensation for every aspect of that. So you could see substantial increases in the value of claims arising. So I was talking about this statutory duty representing a significant change in the landscape in terms of what is expected of employers. And as I say, the 25% uplift threat is designed very much to focus employers' minds on, you know what, we really should be doing these kind of things. So the Equality and Human Rights Commission published some technical guidance shortly before the duty came into force last October. 8 steps on what employers could be doing to prevent sexual harassment at work. And I've listed the headlines of the 8 steps on this slide. So it's employers should have effective anti-harassment policies in place. In particular, because this is about a duty to prevent sexual harassment, those policies need to cover sexual harassment in clear terms, setting out the kind of behaviour that is or could be sexual harassment. So give examples, set out in clear terms what will be done about it if it is raised with the employer, what options and range of options are open to the employee to speak out about that behaviour, whether it's behaviour they've been subjected to or behaviour that they have observed. What we're seeing on the back of that is an increasing trend that employers are having standalone sexual harassment policies as opposed to having sexual harassment as a section of an existing anti-harassment and bullying policy. Secondly, businesses should ensure that all employees, workers and contractors are aware about the employer's new duty, about the anti-harassment policy and the stance that the employer is taking to eradicate sexual harassment. That should include giving them awareness about how to report harassment and the consequences of breaching that. The third aspect is about doing a risk assessment. And this is really important, actually, because you should be carrying out workplace risk assessments to try and identify areas where there's a possibility of an increased risk of sexual harassment occurring. So that can include areas where people might be working alone, but interacting with third parties, such as contractors, members of the public, and so on, customer-facing roles. What the Equality and Human Rights Commission view is that unless as an organisation you have carried out a risk assessment of all the areas of your business where and identified the ones where there's a greater potential risk of sexual harassment occurring, it's going to be very difficult for you as a business to be able to show that you've complied with the statutory duty as a whole. So a risk assessment really ought to be the first action that is taken here. Reporting routes, recommending that employers give individuals different reporting routes, different ways to raise complaints of harassment. And that could include online reporting, anonymous reporting, independent third-party phone lines, and so on. Different routes to raise concerns, not just via line management or with human resources. New training about what sexual harassment is, what to do if they experience or see it, how to raise complaints, how to tackle complaints. This training really should include third-party harassment. This should be repeated on a regular basis, ideally on an annual basis. And it should also be monitored so that you can understand whether the message in the training has stuck with the workforce. Sixth one is dealing with complaints swiftly, properly, making sure that they are take account of what the individual wants in terms of an outcome, but without any commitment on that part. But the handling of complaints is a really important one, making sure, for example, that you've got adequate experience and resource internally, if needs be externally, to investigate complaints sensitively and confidentially where possible, getting to the nub of the issue and reaching conclusions so that action can be. Seventh thing is making sure that you consider third-party harassment. Treat third-party harassment just as seriously as harassment by an employee. So think about putting reporting mechanisms in place and assessing whether any of your individual workplaces might be higher risk in terms of harassment by third parties. And then finally, regularly monitor the effectiveness of all of the above and see if there's any areas where you have fallen short, looking at what else that you can do. So it's a clear and quick 8-step guide of the kind of things that employers ought to have in place to be able to show that it can comply with its statutory duty to prevent sexual harassment. And many businesses have been taking some of these steps. I have yet to see one that has taken all of these steps, or many that would be really confident that they have done enough to comply with this statutory duty. But there is a summary of the areas of your business that you ought to have been looking at. And if you haven't been looking at them, then it's absolutely something that you ought to be looking at going forward, because that duty is going to get stronger when it comes to the Employment Rights Bill. So, Anthea, on to the next slide, please. I'm going to cover the 4 main EDI-related changes that are coming into force in the Employment Rights Bill. I'm not going to mention, and if people wish, I'd be happy to discuss on a similar forum to this in future some of the other ones, such as equality action plans that are going to be implemented, likely sometime in 2027. Don't yet know when in 2027 hasn't been announced. Proposed increased protection for pregnant workers. Review of family leave arrangements across the piece, so not just maternity or adoption leave, but all family leave arrangements are to be reviewed, but won't report back on the findings of that review for another 18 months or so. So it's too premature to talk about some of those changes. So the main ones I want to cover are, and I'm going to quickly whiz through these next 4 slides, Anthea. Changes to the reasonable steps defence. Next slide, please. Third-party harassment. Next one, whistleblowing changes, and then the final change, that is changes to NDAs or gagging clauses. So first of all, changes to harassment. Well, as the Worker Protection Bill was going through Parliament in 2023, Labour said this isn't enough. It should be a duty to take all reasonable steps to prevent sexual harassment. It was watered down by the Conservative government during the House of Lords debates. The government, Labour committed to changing the duty to all reasonable steps, so that's coming in. So the duty on employers will be to take all reasonable steps to prevent sexual harassment. What will be all reasonable steps is to be confirmed. The bill contains a section that says the Secretary of State will make regulations that set out what reasonable steps will be. I think it's safe to assume that it will be at least the 8 that I just mentioned from the Summary Equality and Human Rights Commission guidance on an earlier slide. There may be more to that. This change, the duty to take all reasonable steps, is due to come into force in October next year. And at the same time, we're going to have a reintroduction of employers being liable for acts of harassment, not just sexual harassment, any acts of harassment carried out by third parties towards its employees where the employer has failed to take all reasonable steps to prevent that from happening. Whether the all reasonable steps in that context is going to be the same as all reasonable steps in the context of employees and their behaviour will remain to be seen. But bearing in mind that there is a lesser degree of control that a business will have of the actions of third parties, logic would suggest the all reasonable steps benchmark in relation to third-party harassment will be lower than the all reasonable steps benchmark for duty to prevent sexual harassment. So third parties, though, is likely to include acts by clients, customers, contractors, visitors, guests, and that an employer will be liable for any acts of harassment by those in categories of individuals towards an employee if they haven't taken all reasonable steps to prevent that from happening. So the kind of steps that would be needed, again, would be a risk assessment of the likely areas of your operations where there's a risk or potential risk of harassment by third parties. Training of staff and managers about what to do if there's harassment by third parties. Updating policies so it gives employees an understanding of if they are subjected to harassment by third parties, what they are entitled to do about that and what they ought to do about that. Notices also in workplaces about acceptable behaviour, and then addressing complaints promptly by way of removing the offending individuals. And if the behaviour is completely unacceptable, then looking to prosecute complaints as needs be. So this duty, these two changes, duty to take all reasonable steps will come with the same teeth, the same possibility of an increase in compensation of up to 25%. I think that it's proposed also that the harassment by third parties could also lead to an increase in compensation of up to 25% if the employer hasn't taken all reasonable steps to prevent that from happening. So what we are going to see when this provision comes into force, and it's due to come into force, assuming the bill passes Parliament, which is due to be sometime next week, when the final reading is due to be in the House of Commons on Monday. Royal assent is expected before the end of next week. From October next year, an uplifting further still of employers' obligations with regard to harassment.
Paul, can I just stop you? Can you still see the screen?
Yep.
Because I've changed computers. Great, okay.
I can, thank you. Lovely. We're back on, Anthea. All okay?
Great, yeah, I'm on a new computer now. Just in time.
Good. Okay, if you can just move the slide on, please. Because another change that's proposed in the bill is an extension of whistleblowing protection. This is due to come into force next April, and a report by an individual of sexual harassment to an employer will be a protected disclosure. It also means that that individual is allowed to make that report to a third party, such as the Equality and Human Rights Commission, without fear of being penalised by their employer for raising matters externally. I think this has a number of implications. But just to be clear, many sexual harassment complaints at the moment will also be protected disclosures, where, for example, a complaint references that a person has perpetrated sexual harassment towards several individuals. That would be enough, I think, for it to amount to protected disclosure anyway. But a single complaint of a single act of sexual harassment against a single employee will be a protected disclosure. If an individual is dismissed in consequence of having raised a disclosure, and heaven forbid that you think that would ever happen, but let's just say, for argument's sake, somebody speaks up alleging that the CEO sexually harassed them, and in response, the CEO terminates that person's employment. Well, that individual would be allowed to, post-April next year, make an application for interim relief. That is a rare claim in an employment tribunal, has to go through very quickly, have to be raised, I think, within 7 days of the termination of employment. Don't have to go through ACAS early conciliation, you go straight to tribunal, but the tribunal will expedite a hearing for interim relief. By expedite, I mean at this stage still several months away because of the delay in tribunal systems. But the theory is an expedited hearing, and it's just to hear the application for interim relief. And if that application is successful, the tribunal will order the employer to reinstate the employee with back pay and carry on them in employment until the substantive hearing of their claim relating to the dismissal, which might be another year or 18 months or so away. It's quite a powerful tool in whistleblowing cases. So somebody who's dismissed because of having made a sexual harassment disclosure could seek to pursue interim relief. That's quite a substantial change. I think another important aspect of this, though, is that it automatically means that any settlement agreement entered into by an employer with an employee who has raised complaints of sexual harassment in the past, that sexual harassment complaint, the employer's response to it, and potentially the settlement of that complaint by the employer by way of the settlement agreement cannot be included in the scope of the confidentiality provision in that settlement agreement. So the employers who might have started or taken the approach to date that if we receive a sexual harassment complaint, yes, of course, we will investigate it, but if there's an opportunity to bury that bad news under the carpet, exit the employee on amicable, in quotes, terms with the settlement agreement, that as a practice is going to be something that is fraught with a great deal of risk for employers, to the extent that I think it will die out, and hopefully it will die out. It will mean, I think, that employers are far more likely to do the right thing from the outset when a sexual harassment complaint arises and investigate it thoroughly and take appropriate action based on the findings of that complaint. It doesn't necessarily mean settlement agreements aren't part of the range of options open to the employer to deal with matters, but it shouldn't be the default position for employers. And I think that's reinforced by the final proposed change. And if we can let's go to the next slide, which is an amendment that was proposed at the House of Lords. So it hasn't yet gone through and been accepted by the House of Commons. It's likely to be, because I think this is one that was proposed by Labour peers, but I haven't also got a likely implementation date for this one. Sense tells me it's likely to be either April next year or October next year, so it'll coincide with one or other of the the amendments or developments that I've already talked about. But non-disclosure agreements, confidentiality clauses, gagging clauses, call them what you will, any provision that seeks to prevent an individual from disclosing details about harassment or discrimination, relevant discrimination, that they've been subjected to in the workplace, or the employer's response to that harassment, will be a void provision. So any confidentiality clauses in employment contracts, or more likely in any exit settlement agreements, to the extent they seek to prevent people speaking up about discrimination that they were subjected to during their employment, whether it's harassment or otherwise, those provisions are going to be void. The detail of this needs to be thrashed out still, because it suggests, the amendment that was proposed in the House of Lords suggested that banning of NDAs in respect of harassment and discrimination issues will not apply to accepted agreements, which might include circumstances where an individual employee or claimant in an employment tribunal says, I've been subjected to this behavior, but actually I do not want anybody to talk about it. The last thing I want is that to be in the public domain. Therefore, I am wanting there to be a confidentiality provision relating to the discrimination or harassment I've complained about, and your response to it to be included in any settlement agreement that I may enter into. I'm demanding confidentiality. Speaking from experience, that does happen on occasion, but not that often. It's usually employers that are the party that would prefer to have confidentiality. But I think this is an amendment that might have some unintended consequences. First of all, I think it will drive employers to a point where they are investigating issues promptly and making informed decisions about how they want to resolve what might be an otherwise intractable situation or relationship breakdown between two employees. Do the investigation and make an informed decision on matters, because of the risk that any settlement agreement, which might seek to include a confidentiality provision, that provision being void and the individual being entitled to raise, in public if needs be, details of their experiences when they were with that business. Just to be clear, it doesn't stop settlement agreements. It will not stop a settlement agreement validly settling the legal claim and the liability for compensation that could have flowed from acts of discrimination that an individual might be subjected to. It just can't stop the individual speaking up about the behavior that they were subjected to. Now, in cases where the employer has done an investigation and hasn't found any substance to the complaint that's been raised, this development actually might be unwelcome, because it may mean that individuals who are keen to settle aren't able to settle their cases because the employer might be concerned that it won't be able to put in a suitable confidentiality provision in the settlement agreement. Either way, this development, I think, is going to change tactical considerations for all businesses when they're dealing with how to resolve a dispute, whether that's an internal claim or grievance, or it's a matter that's in the tribunal forum already. But at the very least, the bare minimum, and I think this is a really welcome implication of this change, I think it drives employers to properly looking into what has gone on, and where things have gone on that shouldn't have gone on, proactively then reinforce the need to take all reasonable steps that they can take to try to ensure that that kind of behavior doesn't happen again. That will help in terms of future claims that might arise relating to harassment and alleged failures to take all reasonable steps. So if I can just flick on to the last few slides, Anthea, I've got in the next 3 slides just a potted summary of the kind of things that we believe as employment lawyers will be the minimum that employers might need to take to be able to have any chance of satisfying this. We've taken all reasonable steps. Again, I'm reinforcing, I've moved it from number 3 from the ECHR technical guidance up to number 1, because I think it's the most important thing that you can do is carry out a risk assessment and then put in place an action plan of things to change based on that risk assessment. Where are the areas of risk? Who might be at risk? Who might harassers be? What action can be taken? What can be done to protect the employee? Have a policy, make it clear, regularly update it, and make sure it deals specifically with sexual harassment. Have a standalone sexual harassment policy if needs be. Consider having workplace champions to provide support and advice to those who experience or witness sexual harassment. Next one, please, Anthea. Mandatory staff training on what amounts to sexual harassment, behaviour expected in the workplace, how to raise complaints. Additional training for managers about what they should do if they see inappropriate behaviour, stepping into the shoes of a manager, what you as a manager should be proactively doing to protect employees who report to you, to protect the business from a potential exposure. That additional training might include investigation skills training, interview skills training, report writing training, analysing evidence and things of that nature. Also, zero tolerance approach to sexual harassment should come from the top down. Behaviours at the top should be challenged just as much as behaviours at a more junior level. Think about what steps you can do to encourage reporting of sexual harassment. I don't personally think it's a bad thing that if employers put in place numbers of different routes, if numbers of reports increase quite significantly. That, I think, it would be a sign that people feel more confident about speaking up about inappropriate behaviour. What's important then is that there's a clear understanding, and there's visibility amongst business that those complaints were worthwhile because the business has done something about that. Conduct regular staff surveys to identify the extent of the problem and engage with employee groups or trade unions where you recognise trade unions about steps that can be taken to try to highlight this as a potential issue and what steps can be taken to mitigate that. And a final slide on this one is make sure that when things go wrong, you take effective measures. So you have an effective complaints handling procedure, you are robust on disciplining people who have misbehaved, and that you take appropriate actions when people have carried out behaviour that warrants termination of employment. Making sure that you try to then address the aftermath appropriately through use of employee assistance programs, through, if need be, sharing with victims details of specific outcomes that have been meted out to people who have perpetrated acts of sexual harassment. And then making sure you can take reasonable steps to ensure that no victimization takes place. So I think they're a summary of the main things as a minimum that employers would need to do if they want to have any prospect of satisfying their obligations under this enhanced duty to take all reasonable steps to prevent sexual harassment. So in summary, the effect of these changes, Anthony, this is on the next slide, please. The effect of these changes in summary, four things. Aim for employers to establish a culture where harassment is not expected, is not tolerated, is not condoned. Training about workplace behaviour becomes the norm. Regular sessions, not just on induction, not necessarily just on an annual basis, but regular repeated sessions for all employees. Think about what you can do in terms of your culture to foster respect and inclusivity, acceptable dialogue, unacceptable dialogue, acceptable conduct, unacceptable conduct, and make sure you have clear guidelines on what behaviour is or is not acceptable. These four things in a nutshell are the areas that in any claim that arises relating to sexual harassment, harassment in general, or harassment by third parties, these are the four areas that employment tribunals will be applying scrutiny to in terms of what employers have or haven't done. Don't get this right. Not in addition might you face the implications that I talked about in terms of reputational damage, claims arising, staff turnover or otherwise, but you run the risk there of losing valuable resource and employees and potentially impacting the brand's reputation for many years to come. So just as a final observation and final comment, this is the sole plug that I'm going to give to Gateley Legal and our services on this session. On the next slide, I've just put in a few points of areas where we can provide support for businesses when they're looking to dealing with harassment and looking to comply with the existing duty and what is coming ahead when the bill comes into force. We provide legal updates, seminars. We can conduct workplace investigations, or we can train people on conducting investigations. We can provide training for people on the duty to prevent sexual harassment. We can carry out DEI audits, so you can help. It's part of a risk assessment process to identify potential areas where you might want to focus your energies to begin with. One of the benefits, by the way, of a DEI audit carried out by us is that it's subject to legal privilege, so it wouldn't be something that would ever be disclosed in subsequent legal proceedings, meaning that if we did an audit and come up with a load of red traffic light things that are action points to address, you haven't got the resources to address all of those in the next financial year, you could put them on a list of things that you are going to address over a future period that is suitable for you, bearing in mind your resources, and without the fact that they've been highlighted to you now being something that comes out in disclosure exercise in any subsequent litigation. Finally, we can help with leadership development, cultural change programs. They are our sister businesses, T3 and Kiddy and Partners. I won't say any more than that. There's more details about all of those on our website. But if you would like to learn any more from us, hear from us about any more of those things, then the feedback link that I'll send to you, Anthea, for you to circulate, please just put some details in there, and we're very, very happy to provide more details. And Anthea, if you can go on to the next slide, that's where the QR code to download these slides is. So hopefully that has been helpful summary, a bit of a whistle-stop whiz through some of the main implications. Hopefully it's been useful for everybody, and that I've given you some food for thought and some action points of areas you might want to have a look at. Thanks for your time.
Thank you, Paul. Can you hear me? Yeah, great. Just conscious of my microphones. I'm not using my microphone. Thank you, everybody. So I will send these slides out to everybody, so you'll get the slides with the QR code on them. Has anyone got any questions for Paul from today's session? Either come off camera and ask your question, or put it in the chat. And while you're thinking about whether you've got any questions, just to let you know, I'm going to stop sharing in a second, just to let you know to do now is that was the legal framework. What we're planning to do is run another webinar. I need to set the date, but probably in about 6 weeks' time, where we're going to ask a couple of our strategic partners who've already done some work on those 8 steps that Paul outlined, to tell us what they've been working on and what they've learned from the work they're doing. So we're going to have someone from Baxi and someone from Knauf telling us about the work they've done, and we're inviting other people to come on the call as well to share what you've done or what you're planning to do, and maybe ask questions about the practical side of putting reasonable steps into place to prevent sexual harassment. So keep an eye out for that, and anyone on this call, I will send an invite to that once we've set the date. But I see we've got a question from Chris. So Chris is asking, for organisations operating across different countries, does the training obligation just apply to UK-based employees?
I think the answer to that at face value would be yes, but there's a big but to that, which is to the extent that any employees overseas might be interacting with UK-based employees, then they need to be aware of what standards the UK-based organisation has in place with regard to acceptable behaviour or not, because if it doesn't train overseas employees about anti-harassment and bullying, sexual harassment obligations, etc., there's a risk those individuals might behave in a manner that's contrary to the policy. And I think that would mean that, well, first of all, to my mind, that would be a reasonable step that you could easily take by extending the training. And if you don't take it, I think there would be a significant likelihood that a tribunal would conclude, why didn't you contemplate doing that? As part of a risk assessment, did you look at the areas where your UK employees interacted with other people where there could be an increased risk of likelihood of sexual harassment occurring? And if you didn't explore the areas where your operations are overseas, did you do an effective risk assessment? So indirectly, I think the answer to that is no, it doesn't just apply to the UK-based employees. It applies to every employee where there's a degree of interaction with the UK business.
Great, thanks for that. And Chris says thanks. And we've got another question from Kimberly. Could an employer be scrutinised by the method of training in terms of all reasonable steps, such as online video versus in person?
Well, it could be criticised if it's done online training, which is one that somebody can simply kind of click through without necessarily being tested that the message of that training has stuck home. So there needs to be, as a minimum, some kind of measured assessment that you keep records of, that, you know, with a minimum pass mark that people are expected to do. And I think it would be important to make sure that that's training that can't be gamed, so that one person does it and says, oh, these were the answers to the questions at the end, do that and you get them right. So perhaps if it's a 10 question multiple choice, that there's a range of 25 or 30 questions that might be generated for any given individual, so it can't be gamed in that way. I think it's also important that whichever you do, online or in person, and what's right will be suitable for your organization. And if you've got a lot of employees who are based all over the place in different locations, it might be difficult to easily get everybody in one location for the purposes of in-person training. So you might default and say that online training is better for our needs. But what's quite important is that whatever you do some kind of testing of the message, and then you repeat the training, so the message doesn't sort of get diluted or forgotten over time. So clients we deal with will perhaps do a mixture of both. We've had quite a bit of traction with businesses wanting face-to-face training for managers about the duties of event, which includes, you know, more in depth around speaking out, challenging behaviours, calling out unacceptable behaviours in the right way, and also a little bit about what might be involved in things like suspending an employee who's accused of sexual harassment, carrying out an investigation, what kind of things need to be done in interviews, in investigation, and writing reports. That's much more effectively done face-to-face than perhaps online, whereas for every other employee, it might well be that online training is appropriate. So you could be scrutinized if you only do one without thinking about what's the right method. But I wouldn't say it stands to reason that you will be criticized if you only do it online.
Thanks for that. Any other questions? We've got about a minute left. No, looks like we're okay. Okay, so thank you very much for everyone attending. Sorry about the technical difficulty, particularly Paul, because you had to deal with that, but we got there in the end. I thought the whole thing was going to crash. So I'm glad we got to the end. I will send out the slides with a QR code for everybody. And Paul, you're going to send, is the feedback form you want, is that going to be on that QR code?
Yeah, well, no, what I've got is a link that people can click, and it comes to a very brief, literally, I think it's 4 questions, 3 of which are yes, no, form for people to complete with a little bit of feedback.
Please do that, because it really helps Paul, and so please do the feedback. So we'll send that through to you, and I'll be in touch with everybody who's on this call with the date where we're going to get some real employers talking about what they've been doing, and so we can actually delve into the reasonable steps in a bit more detail. So thanks everybody for joining us today, and hopefully see you all again soon. And thanks Paul for giving up your time to run the webinar.
Not a problem. Happy to help. Nice to meet everybody. Thank you.
Thanks very much.
Thank you.
Bye.